asked her, she told me that they had sent a notice of eviction, which they did not. They sent a notice to quit, which she in turn then hung up in my face.
Versus Baltimore. And for the record, Mr. Kesky.
Good afternoon, Your Honor. Don Kesky for the plaintiff. Also online is Deborah Wren from DTN, which is the agent for the owner, Your Honor.
Okay. So I don't know if this is a Miss or Ms. Mr. Baltimore.
It's Miss Baltimore, Your Honor.
Miss Baltimore, how are you?
I'm doing well, thank you.
Good. Do you have any questions of me?
I don't at this point in time, no, sir.
Okay, so the idea here is that the actual hearing with regard to this matter will be on January 11th at 2 o'clock. It will be a Zoom proceeding just like today. And I'm going to send you this notice that's going to have a list of some resources that you can avail yourself of. Okay. Have you applied for any type of assistance to help you so far?
Yes, sir. I put in a state emergency relief request to the Department of Health and Human Services. I haven't heard back from them just yet.
All right. You might want to use this as an impetus to contact them again to let them know that you've been to court and that you hadn't heard from anybody. So you want to get that ball rolling with them, okay? Because the 11th will be here pretty quick.
Yes, sir.
All right.
Yes.
All right, then I'm going to let you go at this point, okay, Miss Baltimore?
Okay. Thank you, Your Honor.
You have a good holiday, okay?
You too. Thank you.
Thank you.
Yeah, and
Next matter is case 233337. This is DTN Management versus Kalia Baltimore. Ms. Baltimore, are you there?
Yes, Judge,
Your Honor,
I'm
this
here.
is Brian Coyer on behalf of the of DTN.
Okay. Ms. Baltimore, are you being represented by an attorney?
No, sir, I do not have an attorney.
Or you want to tell me what's going on?
Your Honor, this case involves a judgment for possession and money for rent and costs based on a lease. Apparently, there has been no payment for a period of time. I'm here with Deborah Wren, who represents DTN in this matter.
Okay. Ms. Baltimore, do you understand what's going on?
Yes, sir, I do.
You're saying that you owe rent and that you haven't paid. What's your position?
Yes, sir. Yes, sir, that is correct. I've had an issue. I was taken down from a full-time position to a part-time. That impacted me greatly. I'm a remote worker out of DC, and they changed my position to part-time abruptly, and so that hindered me financially. When we came to the pretrial hearing, I had applied with Department of Health and Human Services for assistance. I was just speaking with the caseworker this week, and unfortunately they had to close the case because I have an open child support application that required some additional information that needed to be taken care of that I'm not able to handle with child support because I haven't received the information as to what they need from me. So she said until the child support office can clear whatever is missing from their record, she wouldn't be able to assist me going forward. And no other agency would help me until I got a denial notification from Department of Health and Human Services. So I am actively trying to get assistance and just hoping that the property management would work with me in this matter so that I can get it handled going forward.
Okay. Mr. Coyer, you heard what Ms. Baltimore had to say, your position?
I believe that it would be appropriate for us to go into a breakout session to discuss this further. And Ms. Wren, of course, is going to have to speak on behalf of the client here as to whether or not she's going to be prepared to discuss any terms with the defendant.
Ms. Baltimore, do you understand what's going on?
I believe so. They want to discuss it further. I'm understanding.
They want to discuss it further, and they're probably going to try and enter into some form of an agreement with you that you will either move or bring your payments current in a specified period of time. And if you fail to bring it current within that specified period of time, they will be able to automatically seek your eviction.
Okay, yes, sir. I understand that. I would love to discuss that with them.
Okay, we'll put you in what's called a breakout room so that you can have a discussion with the attorney and Ms. Rand, okay?
Thank you, Your Honor.
Okay, thank you.
All right, hold on.
I'm here, Your Honor.
Okay, so we're back on the record with regard to DTN versus Baltimore. Mr. Coyer.
Your Honor, the parties met in the breakout session. We discussed the matter. Apparently, there's been no payment on this lease since June 2023, with no prospect of any future payment, and so there could be no agreement on a conditional dismissal. And as a consequence, we're moving for possession and a money judgment. I'd have to defer to the testimony of Ms. Wren for the exact amount. The statutory period of 10 days should apply with regard to eviction, but the defendant would have until January the 22nd to make all payment and retain possession.
No money judgment is being asked.
So just a possession judgment?
Yes, Your Honor.
Okay,
And I understand the 10 days comes after you've signed it.
right. Ms. Baltimore, you understand what's going on?
I guess I'm confused about the no money judgment. I do understand she said that from the notes that I've taken, if I was to make the full payment by the 22nd, I could remain in the property. If not, then I would be evicted.
Well, that's essentially true, but what she's saying is that they can just look for a termination if you don't move by the date that you should have paid the money by. It sounds like that date's gonna be January 22nd.
Yes, I did understand that. Yes, sir.
Okay. So then the judgment will be for the landlord for possession, and hopefully you'll be able to come up with the money, but you have to pay every penny that you owe at that point.
I understand, Your Honor.
Okay. Ms. Wren, do you know what that exact number would be?
Yes, I do, Your Honor. Would you like the breakdown between rent and costs and total?
Just give me the total.
$9,009.58.
It's a lot of money.
Yes, sir.
Yes, okay. Ms. Baltimore, any questions or concerns before I let you go?
No, sir.
Well, good luck to you, because that's a big chunk of money, and I know that you, as you said, you had an abrupt change in your hours, so. Okay.
Yes, sir.
All right, you're free to hang up. Thank you, Mr. Collier. You have any questions before I let you go, Mr. Collier?
No, we'll file the judgment, Your Honor. The order.
Ms. Wren, thank you for your time.
You're welcome, Your Honor.
Thank you.
Safe.
Ms. Baltimore there?
There's your phone number there.
Yes, I'm here.
Ms. Baltimore, do you have a video or what's going on?
Oh, I just dialed the number. That was no video. I didn't know if we had to do video or no video.
Well, we've actually dealt with each other before, so I don't necessarily need to have video. This is case 233337. This is DTN Management, Care of Holiday Apartments versus Kalila, Baltimore. I think this is actually your motion, Ms. Baltimore, to set aside the default. Why did you file a motion to set aside the default?
Yes, sir. Thank you for taking the time today. I went back to the district county court to request to set aside the default because I didn't quite understand that by going into the breakout room the last time that we were in court on January 11th, that I wouldn't have the opportunity to present some information to you, Judge, that I thought was relevant to this proceeding. I was trying to, at the time, obtain counsel as well as additional resources. And unfortunately, I wasn't able to retain counsel, but did speak with counsel and presented my information to them. And they thought it would also be relevant to present that to you, which is why I asked for the request for this hearing.
Okay, Ms. Jakeski?
Yes, Your Honor. I don't know that there was certainly nothing to mislead her in any breakout room last time, but I note that under the court rule, that's indicated on the judgment MCR 4.201J that the defendant would have a period of 3 business days to, file a motion or file a petition asking to set aside the judgment based on either a misunderstanding or for some other reason, which I do not believe she did. And second of all, the judgment provided for recovery of over $9,000 and for a move out date, pay or move out by January 22nd, and then that was the consent judgment. And now, of course, the balance is higher, that's my understanding. And so it just seems there's no good cause for this motion, besides the fact that her motion filing itself, presents no arguments at all. It's signed by her, but she doesn't present any grounds, arguments, facts, or anything else to indicate what the basis for setting aside the consent judgment would be, which makes it more difficult for us to try to respond, Your Honor, to any unasserted facts or arguments.
Okay.
It's just tremendously late for this to happen, and the balance owed is so substantial that apparently the defendant is not only not willing to pay the balance, but just wants to continue living there without paying any rent. And so that's very highly prejudicial to the property owner, and it's unbalanced and unfair, and we don't feel that she has a justifiable grounds or good cause for setting aside the consent judgment that was entered into with full knowledge at the last hearing.
Okay. Ms. Baltimore?
Okay. Actually, I do believe that I did submit that form you were speaking with about the MCR 4.201J. That's the form that it says that I could and had the right to do if I filed this motion within 3 days of the judgment. When I spoke to the woman at the court office in Mason, she said that information regarding why I was doing this would be something I would present to you today. So if I were supposed to add information to that form, I wasn't informed of that. I didn't know. Otherwise, I would have. When I came into the breakout room on January 11th, the first thing that I asked the property manager was if there would be time to give me additional time to come up with the resources or counsel because I was actively pursuing help with the Department of Health and Human Services. And I was immediately told no. From that point on, she and Mr. Kesky kind of, ran the breakout room session, explaining to me what the amount was for the judgment, how many days I had, and what the recourse was. What I did not get to say is that the entire time that rent hasn't been paid or hadn't been paid at that time was also the amount of time that I was dealing with a bed bug infestation that was completely, it was huge. It was something I had never dealt with before. I dealt with this issue from July of 2023 all the way till December of 2023. It wasn't until I was in the breakout session that I was even notified that I was going to be responsible for the additional funds that it cost to have the final treatment in my home to get rid of said bed bugs. The property manager or property owner had their
can I stop,
pest control.
Miss Baltimore? I need to stop you, okay? Because
Yes, sir.
you're adding a lot of information, and something's going to get lost if we don't kind of break this into pieces that are a little bit more manageable. So
Okay,
first
yes,
thing that you need to understand is that Mr. Kesky has raised an objection to you using the form that you use to try and set aside the judgment. That you use the form that's called a motion and affidavit to set aside a default, and there was no default in the case. The default is when a judgment was entered without your knowledge. And so this is not a situation where this happened without your knowledge. You were participating. And in fact, I believe there was actually either your signature or you had given this permission to Mr. Kesky to sign your name on the judgment form. So that form that you use for this process is inappropriate.
I
Okay?
apologize, Judge. I haven't studied law, so I went to the court to find out what I needed to do, and this is the form that you presented me with.
Well, the clerks are informed by the judges here that they're not to give legal advice. So if you ask for a form, they will give you the form.
I didn't ask for a specific form. All I asked was based on the form that I had received in the mail, that I had the ability to file a motion for a new trial based on the fact that I didn't understand the judgment and that I wanted to present information. So I apologize if I used the wrong form.
I need to apologize, but again, that's why I'm trying to break this down into just smaller pieces so that you don't have a whole bunch of information that you're trying to respond to, that you just have pieces of information that you can make sense of and you can respond to them in turn, okay? So as I was saying a moment ago, since this is not the correct form for this purpose, I'm going to rule that the motion to set aside the default is denied, because in order to set aside the default, first there has to be a default, and then you have to show why it should be set aside. So you understand what I'm doing so far?
Yes, you're saying that I used the incorrect form, so because that form isn't what we're trying to do, you're going to deny that request.
Correct, correct. So now you had raised another question, and you said that you had spoken to somebody at, I think, legal services or something, and you wanted to try and talk about an infestation of bed bugs.
Yes, sir.
Okay, go ahead and talk about that then.
Okay. At the beginning of July, I found a couple of bed bugs in my unit, and I went directly to the leasing office and spoke with the leasing manager there, Christiana, to advise her of the situation and ask for pest control to come out. I had read over my lease, and it said that they would handle any infestations of pests. So she told me that she would get with maintenance and have the pest control people to come out right away. It was an additional 2.5 weeks before they came out the first time. So I tried to get assistance with an outside control, pest control company, but was told they couldn't help me because I lived in a unit that was owned by property, or, you know, had a property manager, and I had to go through them. So I went back to the leasing office and they finally sent someone out. I was then told that they would come out every couple of weeks to make sure that the situation was handled, and, you know, within about a month or so that the situation would be done. From that point on, the pest control person came out again, but told me that he couldn't do anything in my property because I wasn't prepared for the service. And I advised him that he nor the maintenance told me what to do to prepare. So he left and then said that he would come out another day. Another 2 or 3 weeks goes by and he comes back unannounced. I have no idea he's coming. Neither the property leasing office or the maintenance told me he was coming. So I, again, was not prepared and he wasn't able to do service. So he said he would come out in another couple of weeks. At this point in time, the infestation is getting worse and worse and worse. Me and my son are, relegated to staying in my apartment, other than him going to school. Luckily, I work from home, so I didn't really have to go anywhere, but I can't go anywhere because for fear of taking this infestation to wherever I'm going, because I know that it's highly transmittable. The next time a pest control person came out, they did inform me they were coming, so I was prepared, and it was a new person because they said the first person was fired because he, I guess, wasn't acting upon protocol. That person came in and told me that he actually was dealing with the infestation in his own personal home himself. And it made me feel uncomfortable because how is someone going to treat my property and they currently have this infestation in their home, which they could still be transmitting. So I called the leasing office and expressed that concern. From that point on, he came out probably another 5 times. Each time I was prepared for him to come. Each time he said he needed to wait 2 weeks for it to happen. This went on from July till December. At the beginning of December, on one of the occasions he was there, he and the maintenance manager and I were talking, and I said, look, I just don't understand why this is taking so long. This has me like a prisoner in my own home. I'm getting bit, and my son, fortunately, wasn't, I guess some people show signs of being bit and some don't, but I'm being bit all the time. I have pictures to prove that. And I asked him, I said, how long is this going to take? Because this seems extremely long. He said, he didn't know. He was going to continue doing the treatment, and I could continue to do what I was doing to, help boost the treatment and keep it going. And I asked him at that time, I said, my daughter is coming from out of town for Christmas. Is she going to be able to, what do I do? And he said, well, I guess you tell her not to come. We have been dealing with this for 6 months, Your Honor. So at that time, the maintenance manager left, and he came back and he told me that he was going to go directly to DPN and ask them to do something extreme because this was ridiculous. They came out a total of 9 times, 2 of which they weren't able to do something because they never informed me they were coming and I wasn't prepared for the services. It was at that time that DPN approved a heating treatment. I did not know that there was even such a thing because I would have asked for it way earlier than December. And I didn't know that they were going to then charge me for the treatment for something that I could not control. So during this time, I did not pay rent. I did not, I talked to Deb I believe it's her name, from DTN. I explained to her the situation that was going on with my job and how my hours had been reduced. I had always been, upfront and forthcoming with everyone in the leasing office, speaking to them without hesitation. I asked her, she told me that they had sent a notice of eviction, which they did not. They sent a notice to quit. And I told her that DHS wouldn't even help me until I got a notice of eviction that showed I had a court date, which she in turn then hung up in my face. I've been trying to, I don't want to just stay here for free. That's not what I'm trying to do. I'm just trying to work within the bounds that I have and do it a way that's financially feasible for me, and I have been upfront with them since day one. But I don't believe that the amount of rent that I'm paying should be what it is. I believe that it should be reduced based on the fact that for almost 7 months I had to deal with something that they would not help me with, and then want to charge me for it because they had to go an extra measure to get it done. That's why I went to the court and requested this motion for this hearing today, Your Honor.
Okay. Let's see what Mr. Caskey has to say. Mr. Caskey?
Yes, I'd like to ask Debbie Wren if she could respond, but before I do that, what I don't understand is why, as I recall, none of this was brought up at the breakout session or the hearing on January 11th. Is my understanding.
Debbie wouldn't let me speak. She wouldn't let me speak.
Well,
She has been very not nice, and then I've been trying to be very nice to her. She wouldn't let me speak. She was adamant about me leaving. I've been a very good tenant outside of this. I haven't given them any problems or any issues of the like. I don't cause any trouble.
So
them.
let me stop everybody because what I'm about to say is important. Debbie Wren does not control Judge Allen. And so she did not stop you from speaking to me, because when I spoke to you, you told me that you basically didn't have any defense to the claim. I actually wrote that in your file, that there was no defense to the action that Mr. Caskey was bringing on behalf of DTN. So
yes, sir, and you're right.
Go ahead.
I didn't know that I could say that to you, Judge. I've never dealt with this situation before, so excuse me, I apologize. I'm trying to get myself together, but I didn't know that I could say that to you. I felt like when we went to the breakout room, that was an opportunity for the three of us to speak and maybe come to some type of an agreement. And once she shot it down, I didn't know that I had the opportunity to say anything else. It wasn't until late in the evening on the 22nd that I even knew I had the opportunity to come back and tell you that this isn't right. So I apologize that I didn't say anything there, but I didn't know that I had the ability to.
Okay.
Your Honor, as I recall on the breakout room, there was no effort to shut anyone off from discussing anything. And second of all, when it was presented to Your Honor in the court hearing, I believe you are correct that there was no issue like this brought up, and the amount of rent was stated, and she agreed that I could sign the consent judgment, and that was that. And that was the hearing way back on January 11th. And now we have a motion filed, and now it's February.
Well, don't focus on the motion, because I've already denied that as being an inappropriate application.
Yes.
So she's saying that she's had a horrific problem with bed bugs. That she's had that problem with bed bugs, despite the fact that there had been, I think she said, 9 attempts to try and get something done about it, 5 of which actually resulted in a service call when she was prepared for them to come out, and that irrespective of that, none of those service calls alleviated the problem until they did a heat treatment. and she's wondering why they didn't do the heat treatment up front before. And she's also wondering why it is that she got charged for the heat treatment. So if you can respond to those two things.
Yes, and I would ask Debbie Wren to respond on the facts, because these are new facts as far as I know, to me. Debbie Wren, are you on Zoom?
Yes, I am.
Could you indicate what your understanding of the factual situation was and is?
Did you just want me to speak, Your Honor, or should I be sworn in?
Yes, please.
The bed bugs happened a year, almost 13 months after she moved in. The bed bugs were determined to they're not in any other apartment. They weren't in the apartments before her. We traced it back 2 years prior to her occupancy. The bed bugs were, according to the extermination people, the bed bugs were initiated and originated from her. There were 5 treatments that were made. The heat treatment is the last resort. The spray is successfully worked at, we have over 10,000 apartments, and it successfully works as long as the party changes lifestyle and living condition to assist the extermination and the eradication of it. That did not happen. And so we had to move to the heat treatment, which when it's the resident was the reason for the issue, but we were concerned about them transferring to the other apartments above, below, or to either side. The charges that were assessed to the resident, I waived those for her. I told her as much. She told me that the reason she hasn't paid her rent was her hours were reduced, and she had been denied from DHS and twice Health and Human, or Department of Health and Human Resources. She was denied in January.
Let me stop you for just a second.
I never told you that I was denied.
So, excuse me. Ms. Baltimore.
Sorry.
So there was a charge for the heat treatment, but that heat treatment charge was waived?
I waived that, Your Honor, and that amount was not reflected on the judgment.
So it's not reflected in any fashion with regard to the judgment amount?
Not at all. It is not.
Okay.
The balance that's due is strictly rent. Rent has not been paid since last June.
Okay. Ms. Baltimore?
I didn't tell her that I was denied by DHS for assistance. What I told her when she called me, I don't recall the month, it might have been in September or November, was that I applied for assistance, but they will not help you with any rental assistance until you actually have a court date. The only documentation I had from the leasing office was a notice to quit, and that's not sufficient. It has to be an actual court date. So until I could have a court date, which I asked her, was I going to receive one of those? And she said, yes, a sheriff would serve me, and then hung up in my face. It wasn't until later that a sheriff actually served me.
Ms. Baltimore, I really need you to focus on one key thing, and that is that she said that the cost for the heat treatment was waived.
Okay, well, when she contacted me on January 22nd, the amount that she gave me, I believe, included the heating treatment. So I apologize if I misunderstood that.
Okay, all right, so then that's not even an issue at this point. Is that right?
If the amount of the heating treatment was waived, sir, yes. But the amount of
So all we're dealing with are the rent that wasn't paid since June, as well as the court costs.
Your Honor, may I say something?
Sure.
I believe that DTN never sent me the judgment for eviction because of the bed bugs. They sent me one notice to quit, and then I spoke to Ms. Wren after that, and I never received this actual summons to come to court until December. That was months later. So we could, like, they never even tried to evict me before that. I believe they could have, I mean, where the rent amount wouldn't have been as much, but I believe the only reason they didn't do that was because of the bed bug situation. Like she said, she didn't want it going to another apartment. Number one, I have no idea how bed bugs came into my place. I don't know for a fact that no one else here had them. I don't know. I mean, I looked them up and did as much research as I could to find out how to get rid of them myself. And I did change my lifestyle. I've been living out of my basement for the last 7 months because that was the area the first pest control person told me was less likely to have them. So I've been washing clothes and drying clothes and washing clothes and drying clothes downstairs, so that I didn't keep this infestation going. There would have been, like, I don't understand why she didn't send me an eviction notice before then, so that, one, the property wouldn't have had to evict me at this later date.
Let me try to correct something for you. You would not get an eviction notice until I decided that the eviction order should be signed. I never decided to sign an eviction order because we had entered into a stipulated judgment.
No, I mean, before we even initially came to court to see you, Your Honor. They only sent me a notice to quit and never sent me the actual.
Let me explain something further to you. It says on December 8th, 2023 at 12:22 p.m., which is in the afternoon, that court officer Matthew Jenkins served you personally with the summons and complaint. So in that summons and complaint, that would be the notice to quit. And they would advise you of what your rights are. And so you availed yourself of those rights, which is why we ended up having a hearing, which is how you avail yourself of the rights, is by having a hearing with the judge to examine what's going on with the case. And so that ended up with us actually having the proceedings on January 11th, where we ended up having a judgment entered that you allowed Mr. Kesky to sign on your behalf.
Right. I'm saying that he said that rent hadn't been paid since June. This court summons wasn't received until December. I'm saying that I don't believe they ever tried to submit a court, request for this summons all that time because they knew that the bed bug issue was so prevalent and they were trying to keep it from going from another place. What I'm saying is, I guess I'm misconstruing my words, but when I talked to her months before this summons was received, the only thing I had received from them was a notice to quit. I advised her when I tried to get help from DHS, they said they couldn't help me until I had an actual court date. So she said that a sheriff would serve me. He didn't serve me for months later. And that caused the rent to increase and increase and increase.
Your Honor.
Remember this though, too, Ms. Baltimore, is that irrespective of when they filed their request with me, rent always, you can't live any place free, of course, right?
Yes, sir. I know that. Yes, you're correct.
There's going to be some accumulation of a debt. Now, the question becomes whether it would be appropriate for them to assess that against you in these proceedings as opposed to bringing a new lawsuit against you. And they could probably bring a new lawsuit against you for any additional rents that become due after the complaint was filed, when you were notified of the notice to quit. But to my knowledge, they haven't decided to do that either.
Well, Your Honor, the demand for possession was signed and served on September 11, 2023. And we did have a court hearing on December 21. in which case the case was adjourned to January 11th. And the tenant at that time appeared and indicated she had applied for rental assistance. And the assertion by the tenant that the reason why there was any delay here was because of some speculation about the bed bug situation is just not supported by the facts.
Well, Mr. Kesky, I'm not even engaging in that discussion, as you can probably tell. That's a non-issue as far as what I'm dealing with today.
Okay.
What summons was sent to me on September 11th, other than a notice to quit? I've never, the summons that I received was
He said it was a demand for possession that was sent to you on that day.
Okay, I guess that's the same thing as notice to quit. I don't know. Don't know what that means.
So is there anything else that you want to bring to my attention, Ms. Baltimore?
I guess really and truly, the main statement that I had was I was requesting a new hearing to present the evidence about the bedbug situation that I had endured for that amount of time. And I believe that the rent amount shouldn't be as much based on that. That was my defense. Also,
okay.
I am actively working. Unfortunately, I had a reorganization that changed my hours from full-time to part-time. I'm not trying to live anywhere for free, but that was the situation, Your Honor.
And I remember you told me that before when we spoke on January 11th. I actually put that in my notes too, that your hours had gotten cut. So if I made it sound like I was believing that you weren't trying to pay your rent, that's clearly not the case, because as I said, I even put that in my notes that you told me that you had your hours drastically cut. So I don't think that Mr. Kesky's trying to allege that either, but certainly, money hasn't been paid. So I think it's probably a fair statement to say that, you haven't paid as you would have liked to be able to pay. But nobody's actually nobody's really bringing that as an issue today. So actually, the way that the rules work, you weren't supposed to even have a hearing, but you just had a hearing with regard to getting that information in front of me. So you get the information in front of me.
Okay.
Okay.
Your Honor, we would ask for your granting of an eviction order.
Well, you've got a process to use for that, Mr. Kesky. This was before the court on her motion. So this is what we were dealing with today.
Okay.
Okay. All right, folks, I'm going to terminate the hearing at this point. I think we've covered everything that Ms. Baltimore was trying to bring in front of me today.
So would you be denying her motion then to, well, she did the wrong. I understand.
I had already done it, Mr. Kesky.
Well, you're denying any relief to the tenant Baltimore at this time, as I understand it.
As I said earlier, she had utilized the wrong form, and this is not a motion to set aside a default. There was no default. There was an actual stipulated judgment as related to the whole issue with bed bugs. I think we pretty much exhausted that question as well.
Okay.
Does that mean, Your Honor, I can't request that there be a look at the amount of rent in consideration for the bed bugs?
Well, as I said before, there is an understanding that when a person files a complaint, when a company files a complaint against you, that they're asking for a specific amount of money based upon the date of the complaint. If they're asking for something beyond that, then I suppose you have a chance to challenge that. But as I understand it, nothing's been paid, period. So I don't know what we're talking about in terms of some additional money when nothing's been paid to date that I'm aware of.
I'm asking for a reduction in the amount that is owed based on the fact that I had that big bug situation.
So
Is that something?
listen to me carefully. Listen to me carefully. When a person with a company files a complaint against you, the amount of money that they're allowed to be able to try to pursue is limited to the date that the complaint was served. When we've got that complaint here in our office, if they said $10,000 on that date, it's $10,000. It's not 11,000 or 12,000 for future rents after that, unless they bring some sort of action before me to try to obtain that additional money.
Your Honor, I think the consent judgment, which was signed, shows the amounts that you granted in the consent judgment. And that would be the amount up to that time, up to January 11th.
I was just explaining to her how this works. She's talking about trying to reduce down what it is that she feels that she should have to pay when we already have a stipulated judgment. And I'm saying that as of that date, that's what's owed. So if something else is being pursued by DTN, then they need to make some sort of filing with the court with regard to that. And then she has a chance to respond to that, talking about bed bugs or whatever it is that she wants to talk about. But as of the date that I signed that judgment, that is a fixed amount that became final after 21 days. Okay.
Yeah.
Okay, yeah. I'm
So, Ms.
just not
Baltimore,
sure what
yeah.
Yes, sir, I'm sorry.
Go ahead and ask your question, Ms. Baltimore.
I was just gonna say, I'm not sure where I go from this point.
Well, I'm not an attorney, and so I can't give you legal advice, because if I tell you what you're supposed to do, then maybe you win, right? Of course, judges are not supposed to be on either party's side. We're supposed to hear the testimony and make a decision. And so I've made a decision with regard to what's in front of me today. And I've explained it probably 3 different ways, but today is a done deal in terms of what it is that I've decided. So if Mr. Kesky wants to try and pursue you for some additional money over and above what's in the judgment that I've already signed and that is final, then I guess that gives you an opportunity to talk about other things.
Okay.
Okay.
Mm-hmm.
But the judgment became final after 21 days from when I signed it. Okay.
Okay.
All right, folks, I am going to take my leave. Okay.
Hey, thank you, Your Honor.
Thank you, Your Honor.
All right. All right. Thank you, folks.
Yeah.
Appreciate your time.
Yeah, bye.
Appreciate your time,
All
sir.
right. Okay.